Good evening, distinguished guests, ladies and gentlemen, colleagues, Professor Mosey, Cecile. Welcome to King's College. My name is David Caron. I have the pleasure of serving as Dean of the School of Law. Tonight is a very special occasion. The inaugural lecture of David Mosey as Professor of King's College London and as Director of the Center for Construction Law and Dispute Resolution. And it's my distinct honor to be introducing a friend. At the outset, let me recall that the decades of the 60s and the 70s in both Britain and the United States were a time that had a measure of disdain for ceremony. The world was to be born anew. And at the outset, I must say that was never my approach at any point. Rather, I have always relished ceremony, and tonight is no exception. Indeed, I regard welcoming students, please come in. Indeed, I regard welcoming students on the first day of university life, wishing them well at graduation, and introducing the inaugural lectures of my colleagues as most pleasurable events. They mark moments in a life that come but once. They mark moments that define all that we attempt to be. We need to remember that the robe is given to very few figures. It's given to the judge, the priest, the professor. Binding all three figures together is a recognition of the authority that comes with the acceptance of the robe and the role it signifies. To decide impartially, to be servant of God, to be committed to a field of knowledge. To be a professor is to be someone who professes, who declares. And tonight's ceremony, a professor's inaugural lecture, marks a moment when we simultaneously celebrate this achievement and gain from such knowledge. When I was first approached about joining King's, I was most familiar with its Department of War Studies and the Center for Construction Law, both known simply as the best. To be a professor at King's is a signal achievement. To be chosen as the director of the Center for Construction Law manifests a deep sign of trust that the much-praised work of the center will find an even more illustrious future in that individual. And thus we come to David Mosey, who I and my faculty absolutely are delighted to have as a colleague, and who daily affirms the confidence that we placed in him. He is a Renaissance man, gifted in many fields. Many of you probably know about the band he's a part of, and he's curious about all fields, which is just a delight to have in a colleague. Although I gather he was primarily engaged in acting, he received his LLB from Cardiff in 1976. A few years thereafter, he joined the firm of Trowers and Hamlins, where he practiced construction law for 33 years, with over 20 of those years heading the construction practice group of some 30 lawyers. He and Cecile had a glamorous life, bouncing from London to Bahrain, where he advised the kingdom, back to London, back to Oman, and finally settling in their home on Bedford Gardens in 1993, where they raised their family. Professor Mosey's achievements and contributions to society are many at that same time. He authored and pioneered the innovative PPC 2000 suite of partnering contracts. Its success led his team at Trowers and Hamlins to win the Legal Business Construction Team of the Year award, and to him winning the Construction Excellence Achiever of the Year award in 2009. 2005, he was appointed joint head of the UK government's National Change Agent Initiative, established to achieve savings and improvements in the procurement of social housing, an initiative which by 2011 had helped secure savings in excess of 14% on a 1.8 billion program and had supported over 500 apprenticeships. In 2012, Professor Mosey was invited to join the Cabinet Office Infrastructure UK Trial Project Support Group and Trial Project Delivery Group, established to attest the procurement recommendations of the UK government construction strategy, work he continues to today. Professor Mosey, ever curious, received his PhD from King's College in 2007 for research entitled Process Contracting and Early Contractor Appointments, the Potential of Conditional Pre-Construction Phase Agreement. King's is very proud to have such a giant in our midst. He brings ambitions for the center, a vision that appreciates the challenges to and changes underway in construction, and he brings excellence in all he does. Ladies and gentlemen, please join me in welcoming David Mosey to the podium.
Crikey, I've never had an introduction like that before. Now I'm mic'd up. Thank you so much, David. Thank you very much, everyone, for coming along tonight. My wife, colleagues, friends, students, clients, some of you fall into several of those categories. I know you were drawn by the title, Putting Builders into Prison, and hoping you'd get recourse for that shoddy extension. Unfortunately, it's not what we're talking about. We are going to talk about the construction industry, and we are going to talk about change and the capacity for lawyers and contracts to support that change. And some of the change we're going to look at is in the field of cost savings and design improvements, but also in terms of social commitments, primarily to employment and skills, but there's a wider social agenda as well that oddly can be combined with cost savings and design improvements. We've got quite a big industry here. I mean, it accounts for 2.93 million jobs. That's about 10% of all the jobs in the country, and about 6.7% of the economy, about £90 billion. I suppose the relevant thing to say is that back in 2007, it was 8.9% of the economy, and the recession has hit the construction industry very hard, as indeed, of course, it's hit the government very hard. And it is interesting that in the teeth of a recession, we've had, I think, the most effective drive for improved efficiency and intelligent improved efficiency that I've ever seen in the construction industry. And I make no bones about it, the government construction strategy, whatever anybody's politics, is a very well thought through document. You'd expect a recession to give rise to a complete free-for-all, lowest price, cutthroat bidding. It's given rise to something quite the opposite, a forensic look at value and the mechanisms to achieve that value. And as I say, alongside that value, social benefits, environmental and employment and training initiatives that society needs as much as it needs the built projects themselves. So it is interesting, and we have, at a time when we're looking at things forensically to get better value, a bit of a windfall. We have some advances in technology that the government have picked up. A thing called building information modelling that I will come back to is a medium for getting a much more forensic approach to looking at your construction projects, to actually unpick them, put them back together in a more effective way. I'm going to talk about that, and I'm going to talk about, I suppose, how we unite an amazingly fragmented industry. It is tribal, there's no doubt about it. It is extraordinarily hierarchical, and as the lawyers here will know, it is somewhat prone to disputes, to say the least. The source of interesting case law that we have in this country that owes a... Come in, gentlemen, come and take a seat, please. Christian, Rona, go on. I know I greet latecomers personally. It's a great way to really make them feel terrible. Draw attention to them. Yeah, that's only fair. Okay, but a little bit about where I've come from in this and why I have got myself into this position of trying to affect, to some degree, the changes that are in motion. going back, I was looking at formative influences, and the first of these is a gentleman called the late Anthony Gosselin Trower, known to his colleagues as Cocky, and I was a trainee with him in 1978, at a time when I was doing some amateur dramatics, as David brilliantly remembered, after Cardiff, and he rang me up at the end of one day and said, "David, I hear you affect to be an actor." And I thought, oh wow, you know, he wants to know what play I'm in, and you know, this is really something. I said, "Yes, sir." He said, "Well, how would you like to act as a wine waiter this evening?" And so I think, apart from puncturing my vanity, it was a message to take the law a bit more seriously. Moved forward a couple of years. I was very lucky to be appointed to advise the government of Bahrain in 1980. I went out there with Cecile just when we got married. One of the first people I encountered was His Excellency Yusuf al-Khamishrawi, now also passed away. Minister of Development and Industry, quite an extraordinary man, just as extraordinary as Anthony Trower. He had come up with the idea that Bahrain, in running out of oil, needed to diversify, and he thought, after the oil, there's some gas. Gas makes cheap electricity. All we need is bauxite. We can do aluminium. And he balanced the entire economy of the country through his own endeavours. Anyway, I turned up, very honoured to be advising him, and told him about something he couldn't do, because it was contrary to the law of his country. And he said, "That's very interesting, David," and goodbye. Off I went, back to my room. And then he sent a car over with a driver and a note in an envelope. Rather fancy-looking envelope, and I thought, oh, you know, maybe it's an invite, maybe it's, I don't know what. And it was a handwritten note, and this is what it said. It said, "David, a legal advisor to be effective must have the acumen to interpret his client's wishes and make them legally possible." In other words, don't tell me I can't do something. I thought it was very, very, very kind of him. Okay, a couple of other points. I think these are the two big issues in terms of what you do with a contract, what you do as a legal advisor. Cox and Townsend were fairly brutal. They said, human beings seek to avoid responsibility and must be coerced to perform using a strict contract applied in an arm's length manner. And just in case you thought they're sitting on the fence, they went on to say that collaboration is not only impossible to achieve, but is an inappropriate way of doing business. So that's one view. I've been challenging that view for a while, as have a number of people I'm delighted to see in the audience tonight. I more subscribe to the view that you can collaborate, and by collaboration I mean partnering, joint working, in a systematic way that I'll come to, but you need to do it through a careful planning process, rather than just a declaration of love, rather than just a tree-hugging, rounders playing parallel universe. The Bennett and Pierce quote, "Partnering works by making careful plans at the start of projects and then relentlessly putting them into effect," is something that I've lived by, certainly for the last 14, 15 years. And it's where the lawyers come into the collaborative working. Now, where does the Ministry of Justice come in? We've got some people from the Ministry of Justice tonight, I'm delighted to say, and hopefully you'll have a chance to meet them later. They certainly have taken a view that contracts can be used to enable, to liberate new commercial practices. They can actually have a benign influence. They're not just restraining or protectionist. They spotted early on that single-stage tendering may look like it gets you a lowest price at bid, but generally gets you a higher price when the project's complete. And they set up long-term alliances. They set up joint planning processes. More recently, they've been working on this thing called building information modelling that I keep mentioning, and certainly on engagement of apprentices. They looked at a linear approach to a project, from an early stage, getting a team at an early stage, carrying them right the way through. And to my absolute delight, they adopted a contract called PPC 2000, which David has already mentioned, and this is not, I'm afraid, the last time that it will feature in my presentation. It just sort of pops up, and anybody who doesn't associate with me obviously hasn't been stuck in my company for more than 5 minutes. It's relevant and it's illustrative, I hope, of some of the things that we're trying to achieve. It works like this, and if you look at the words neoclassical, relational, and enterprise planning, actually you can probably look at the diagram, but if you think of those words, they may help. Very eminent academics I'm going to quote, US academics, which is suicidal sitting next to an eminent US academic. But there we are, I did warn him, I'm going to give it a go. The first one was a chap called Ian McNeill. When I Googled him, he's sadly passed away. But he, apart from being an eminent US academic, was the chief of the clan chief of the McNeills, if anybody knows about the McNeills, and apparently descended from the High King of Ireland. I just mentioned that. He looked at types of contract: a classical contract, a discrete deal, all done and dusted, put it away. A neoclassical contract where you're providing for the future, but you're trying to get some mechanisms, and the constructional students will know change mechanisms, extension of time mechanisms. That's the sort of thing. But then a relational contract that's driven by the growth of the relationship itself, and which some people, in my view unwisely, thought it meant you didn't need a contract at all. I think there's a combination of things here. The relationship's important, but the process builds up the relationship, and the process is a contractual one. Ian McNeill looked at something called enterprise planning, and I think this is a real trick. If you're going to contract with someone early, if normally you go into a building contract when you go on site, about there. If you're going to contract with someone early on partial information, and you need to run a journey with them to full information, which is what this process contracting model does, then you can't be negotiating the whole time. Otherwise, you won't make any progress, you'll feel at odds. Enterprise planning is a bit of a trick. It says if you've got joint activities that you're doing together, you don't feel like you're negotiating at all. If you're building up a picture by going out to the marketplace, behind the main contractor, seeing what they have to offer, inviting them to join this early formed team, inviting everyone to do some thinking and some planning with you, you're doing that instead of negotiating. If you invite someone to put forward a business case and say, please, I really want to hear what you have to say, let's look at the merits of it, you move away from negotiating, and that is the trick. That's the trick of how you get into an early conditional arrangement, not a blank check, not a premature contractual relationship. It's conditional, and it's moving forward to hopefully an unconditional position there. But we're doing it through what Ian McNeill described as enterprise planning. You need to control the time, you need clear activities, and the contract can set that out, and you need mutual gain. But there's an issue in this that I'm going to dwell on a little bit, and that's people. People can mess anything up, and by and large they do. And there's a lot of people. If you've got 2.93 million of them involved in construction, they're not all going to get this at once, and they're not all going to like it. The people, it takes me back to a former colleague of David's, Oliver Williamson, who was at Berkeley, is at Berkeley, and David Tosmi holds 3 professorships in different departments, law, economics, and business. And he is a most extraordinary man. I cited him extensively in my PhD at King's. He went on to win the Nobel Prize. And he's extraordinary. He came up with, or worked on, this game theory of how you measure conflict and cooperation in business dealings. And suitably for the title of tonight, he looked at something called the prisoner's dilemma. And the prisoner's dilemma is that parties who are put in a given situation may think they're looking after their own interests, when in fact looking after joint interests would have been a better solution. So very briefly, 2 prisoners kept in isolation. The tougher charge can't be made to stick, but police try to get them to grass each other up. If they grass each other up, obviously they commit each other to the tougher charge. If they keep stum and don't say anything about each other, the police can only ever put them away for a shorter period of time. Interesting one when we're talking about MOJ projects, but it's to do with the complexities of human behaviour. We're not entirely self-interested. If I go back to Adam Smith and Wealth of Nations, he says you can have self-interest combined with the good of society. People actually will look to something that's altruistic up to a point, and it's crafting a pragmatic way of getting them to do so. There is, as Oliver Williamson pointed out, no universal morality in terms of the legal and contract. Well, there are contracts, there are commercial norms. In our common law jurisdiction, we have judges who will try to interpret, might try to imply terms. We have statutory implied terms. We try and help people along. But at the end of the day, the morality of it is business. And you can't complain if people are looking after the interests of the company that employs them. you can try and align that with some kind of cooperation. So that's what this thing does. It's a form of social Darwinism. This is quoting another great person, Robert Trivers, who said that if you both benefit from seeming altruism, you take the altruism out of altruism, which sounds a bit negative, but it's to get a broader view of self-interest and also building up what they call their social networks of reputational importance. If I'm working with these people and we're looking after each other's interests and I just step away from it and let them down, my reputation suffers. There are a number of reasons for me to continue to work in this team. So we're not only looking at a cold process, we're clearly looking at relationships between people. But in the UK construction industry, as many of you that I've worked with will know, it's all gone a bit wrong. Nobody's looked at those degrees. They've said, we must cooperate, we must work together, we must be honest. People are either honest or dishonest, and why can't they just see that? Why can't we forget those contracts and those awkward processes and just all get along? And it is a naive thing. And of course, if it's not clearly expressed and the commitment's qualified, which it often is, people don't do what they've said or don't remember what they've said they do, and they become disillusioned and they revert to type. And that has been a big problem. We've seen non-binding protocols in the world of partnering and collaborative working, the sort of parallel universe of we've signed it, but it's not really a contract. Burson St David's, Humphrey Lloyd said, actually, you say it's non-binding, but if I need to use it as a judge to construe a contract, I will. So we'll forget that one. We had the use of good faith and declarations like that, which again bothered people because there's a lot of English law around good faith and none of it is wholly committed. And even though there are interesting guidelines around the duty of a director or a joint venture partner, we've sought to give a different construction to it and the courts have really struggled. Until last year, when TSG and South Anglia said, actually, if you've got a right to terminate, you've got a right to terminate. You don't have to exercise that right in good faith. So if we can't rely on mutual declarations, we can't rely on non-binding protocols, we need some machinery. And this is the one little story I'm going to tell before I really get motoring on the Ministry of Justice. This is Buick Court in Newcastle. It's built over a dual carriageway. It was an early partnering project, and yes, it was governed by PPC 2000, and it had in it these mechanisms that were the core group. These key individuals, if called to a meeting, had to turn up. If they didn't turn up, they didn't get a vote. If they did turn up, decisions were unanimous. Now, nobody could be voted down, but you've got to turn up. And when you're in a dispute, the last thing you want to do is go to a meeting with the people you're in dispute with. On this, it was forced through. There were problems. A subcontractor became insolvent. The client said, that's the contractor's problem, I don't care. The project manager said, no, you've got to come to the meeting. And at the meeting, the contractor put forward a very intelligent proposition about taking over the cladding subcontractor's business, hardly any cost or time impact. And the client, seeing the contractor in the room coming up with something intelligent, said, all right, I don't care about my strict contractual rights, this makes sense, off you go. And then delightfully, because life isn't always like this, you can see on the top there some mobile phone aerials. The mobile phone companies wouldn't close down their aerials, and the boot was on the other foot. The contractor could have claimed a lot of time and money for delay. But, like that story of the lion, with the paw and the person who removes the thorn, said, okay, I won't look for absolute recovery. I'll try and find a flexible way through this. And the calling of the core group meeting, the early warning, was the mechanism to do that. You can influence human nature if you create the right environment and give people the opportunity to be intelligent. If you allow them to be polarised, they most certainly will. Okay, we've got a couple of points here around King's College guidance. David has talked about the UK construction strategy and the reports that have emanated from that. And Minister of Justice is among a number of clients who have produced trial projects to test the recommendations of that strategy. And King's has been appointed to put together guidance and to undertake related research as to whether these have an effect. It's a cause and effect thing at the moment. There's all sorts of other potential there. And the early findings, as the guidance shows, is that these procurement methods, this early engagement, this process, this team working, does have a direct effect on costs and does have a direct effect on improved value. But it depends on strong client leadership, and it certainly depends on contractual processes. So interesting stuff. That's what it looks like. I'm showing you that because you can actually download it. It's an absolutely cracking read. I really strongly recommend it to you. And if you're not reading it for pleasure, read it for consultation, because it goes live. It's draft at the moment. It goes live with ministerial launch in July. And anything you care to tell me about it in terms of improvement before then, I gladly take on board. And it's had some nice things said about it by the Government Chief Construction Advisor and by the Minister for Civil Society around the cost savings and around the benefits for SMEs, small and medium enterprises. The 20% there is the Minister of Justice, Cook and Wood, 20% of savings. And there's a strong recommendation this guidance should be followed. So that's great. That, I promise you, I'm not going to talk you through line by line. It's just a very complicated version of the flow chart I showed you earlier. I suppose the only thing I'd say is this, that if you don't go into contract with your contractor till then, which is what you would do under a traditional single-stage approach without the early two-stage open book, then your contractor won't appoint the subcontractors till about then, and the idea that any of them will take an intelligent approach to helping you with your project is laughable, because they haven't got a chance to do it. If you've said, here you are, you're appointed, get on site. The build-up of the team and the build-up of the information is the way that you extract, firstly, a cooperative approach, secondly, really important data. And when we talk about building information modelling later, the extraction of data, knowledge is power, is what we're about here. The only other thing I'd say is there's a little thing that says minimum surprises and misunderstandings, which is a euphemism for no disputes. And how can we say that? Well, it's very interesting. I mean, there's many academic studies on the causes of construction disputes. But if you look at Smith, Murner and Jobling on managing risk, which obviously is avoiding those disputes, they look at additional information, well, you can get it earlier, additional testing and review of the site and the environment you're working in. You can do it earlier if you've got everybody on board. But interestingly, they also talk about improving information and managing organisational interfaces, which is complex language for get a team together and make sure they talk to each other. That's how you avoid disputes. And not self-evidently, as demonstrated by the trial projects, that curve of information, that enlarged team, that enlarged circle, is having a positive impact on the way that projects are delivered. So I'm going to talk about one project, Minister of Justice Cook and Wood trial project, £20 million young offenders institution. You've got the case study, and those of you who are really swotty will have read it. I'm not asking you questions on it later. If you don't ask me difficult questions, I think that's only fair. It does use this process contracting approach. So we're not looking at a classical transactional contract. We're looking at a two-stage build-up of information, and it does use this contractual hub. PPC 2000, everybody signs one document. They all see what each other do. That's quite important. But the other thing I've got to mention now is what do I mean when I talk about building information modelling? And there are some people in the room who have absolutely no idea. So for their benefit, it is think of computer-aided design, think of seeing something in 3D on a screen, start there. It's 3D digital modelling of a built facility. You look at the physical characteristics, but also the function. What does it do? You can do a virtual build, but you can harvest a load of design and cost data and exchange it much more flexibly and efficiently. So in our digital world, we have something, as I said earlier, that is exactly what we need as a means to save money, improve quality, overcome the fragmentation that is rife in our industry. Level 2 BIM is something that we're at the moment. It's different people doing their virtual models, dropping the data into a federated model, a combination of it. That's probably enough BIM information for the uninitiated to be going on with, but it is very interesting. I suppose the other thing I would say is that the way the Ministry of Justice have adopted this approach isn't out of an experimental zeal or naivety. They are very clear about the apparent benefits to all parties, including them, because they've got a big saving to achieve and a lot of prisons and young offenders institutions to build. The apparent benefits. So the demonstrating those benefits to the parties through early appointment, through BIM, means that we're not naively saying, oh, come on, it's in the national interest, be altruistic. We're saying it's in all our interests, and we can see why. And I think that's important. It's a commercial operation. What did we get out of it? When you do go home and read your case study, page by page, you'll find that bringing the contractor into serve on board, bringing their specialist subcontractor SC on board, immediately brought to life a volumetric precast cell proposal, took 6 weeks off the programme, took 85%, £85,000 off just the cost of running the site. It's an example, but that early corporation achieved that. Perhaps more interesting is, well, firstly, the governor of Cook and Wood is Emily Thomas, so it's interesting that it's a woman, I think. I don't know how many prison young offenders institution governors are women, but she picked up immediately on the fact that she could see this thing she was going to get. She could have a virtual walkthrough of all the buildings, highlighting views in and out, and she started contributing to the functionality of the building to meet her needs as governor. And that stakeholder involvement, I think, was very interesting. And then the third one there, I'm going to come back to in the context of getting the builders out of prison. Because it's to do with, I mean, you think, so he's going to talk about service ducts and cell risers. I think I'll just switch off here. It is a servicing of those. And what they did, they actually built a physical model of it in real one-to-one, shall we say, and then laser scanned it into the BIM model. And what they were doing was answering the needs of those who had to maintain them. Now, what happens is prisoners get very bored and very fed up, very angry. What do you do in a cell? You stuff something down the loo to block it just to see what would happen. Or, if you're more ingenious, you run a fishing line down to somebody else's cell, and when you're trafficking drugs or whatever else you want to sell, you use it as a conduit. People are very ingenious, they're very bored. And you need, therefore, to service those risers regularly. And this radically improved the mechanisms for servicing, without obviously stopping the prisoners doing all those things that they have to do. Okay, that's just a visual depiction. I'm not going to dwell on that. It's another way of seeing Cook and Wood, and indeed seeing the benefits that came out of this process. I also just wanted to talk a little bit about context, because this is part of a wider alliance that the Ministry of Justice set up. They've been at this for, as I said, 12 years. This is their second round. They always use PPC, bless them for that, but they have a wider governance. And so there's a reputational issue within the alliance. Those contractors, those team members, they want to do well. So it's not an isolated project, and I think it's fair to say that's something. But then again, and this was another government report, Procurement Lean Client Task Group, the Ministry of Justice got praise for the way they set that up and the savings they achieved even in doing that process. I suppose the thing I just wanted to note here, apart from, again, that wonderful plug for PPC 2000 by the group themselves, is something that builds up to some legal issues. And for those of my master's students who've kindly come along today and are revising for their exams, there is a bit of law. For everyone else, I hope it's not too much law. And it's around the fact that they used this contract without amendment to deal with the advent of BIM. Now, BIM is a big change technologically. There's a lot of issues. There's IP issues, there's IT issues, there's design liability issues, and the contract wasn't changed. And MOJ, who know what they're doing and know why they're doing it, were very adamant about that. And I just want to look at how they got away with it. This is how they got away with it. They took the BIM Execution Plan, which is a wonderfully complex document about how you move through the stages of these contributions and the build-up of these data, And they expressed it contractually through two PPC documents, the partnering timetable, which is a series of key dates up to start on site, and the project timetable, which is a series of key dates afterwards. The dates when all the people who are in their one contract exchange information with each other. COBE. I always have to check this. Anybody here can tell me if it's construction, operations, building information exchange. The data drops, the time when they were exchanging that data through BIM was set out in those timetables and in the parties' agreed contributions. They used the core group in the way that I described at Buick Court to get together to head off problems and to support the design team, keeping things moving, making sure the decisions were everybody's decisions. And they achieved this transparency. I mean, transparency in BIM is really interesting for anyone involved in construction who's been used to the reasonable opinion of the architect, a reasonable period of time, such additional designs as are reasonably necessary, has got a nasty surprise coming. BIM is utterly forensic about who does what when, and reasonableness just won't cut it. So the transparency you get on time, on cost, and on who's contributing what at each stage is hugely exciting, I think, under BIM. Hugely exciting for the construction industry, fascinating for lawyers, and demonstrably good news for the Ministry of Justice. Okay, a bit of law. Please, non-lawyers, don't leave. There's a great case, John Barber referred it to me, my predecessor at Central Construction Law, Eckersley and Binney. It comes out of an absolute tragedy, a methane explosion that one doesn't want to think about. But some interesting issues around the liability of designers came out of that case, including Lord Justice Bingham's wonderful alliteration. The law does not require of a professional man that he be a paragon combining the qualities of polymath and prophet. I think there may be some reassurance in there for the architects amongst us. However, he also said you can't lag behind other ordinarily assiduous and intelligent members of the profession in knowledge of new advances and developments. In other words, BIM's arrived. You don't have to be the best at BIM, but you can't ignore it. So what about state of the art? Could we say it's ahead of what we're doing? Well, up to a point. State of the art is a partial defence, but you've still got to subscribe to rightful practice. What about if we say the client told us to use BIM? We're only obeying orders, and if it doesn't work, it's not really our fault. No, unfortunately, case law there says even pioneers have to be prudent. We have to do the right thing, even if we're joining that vanguard of taking forward the development of building information modelling. What about new information? This is interesting. We're a designer, we're appointed up front, we've done our bit, we walk away, perhaps we come back and have a check on the site. What happens if our design information's become out of date? Well, the designer's continuing duty, it requires reconsideration only if the designer becomes aware, or should have become aware, of the need to reconsider. And of course, BIM, with its transparency, its instant accessibility, is going to make it quite hard for designers to say they weren't aware or they shouldn't have taken a look in order to become aware. So these are questions, lots of questions, coming out of the advent of BIM. And here's some more. Architects who are venturing into the untried or little tried would be wise to warn their clients specifically of what they're doing and obtain their express approval. Well, we've got an answer to that one. MOJ totally signed up for BIM, aren't going to step away from the machine. They're an involved client, they're behind it. But I think the big question is this. What is the status of the information? We've provided information, we've seen information through the medium of BIM, and what effect is it going to have on other team members? Are we responsible for looking at what they do with the information we provide? Are we responsible for warning of errors and omissions that we see in somebody else's BIM contribution? Because we're going to see them. They're going to be very apparent. There's a system called clash detection. I'll come back to that in a moment. But what you do with a clash when you see it is perhaps a little bit more, demanding. Okay, now I'm going to say here that PPC 2000 is indeed an answer to the proverbial maiden's prayer. Several people would know that I will. By the way, two of the people here, Noel Foley and John Kiley, worked with me on the first ever PPC 2000 projects with London Borough of Hackney and Whitefriars Housing. So thank you for sticking with this form of contract, because you were the ones who took the appalling risk of will it work. These clauses have been in there since the beginning. They weren't designed for BIM, but they're pretty handy for BIM. Each party is responsible for errors, omissions, discrepancy in the partnering documents. That includes all of the designs, except to the extent of its reliance, if so stated in a document somewhere, on any contribution or information provided by any one or more others. If you spell it out, what's gone before and your reliance on what's gone before, and what comes next and what you expect of who comes next, you're in the clear. You've got a medium to describe your contribution and to see everybody else's. And without a multi-party contract, you don't get that. Designers are so nervous because they're fighting blind. They think other people have got a better deal, other people have got a let out, so I must defend my corner. And then in terms of a duty to warn, there's one of those as well. If you spot an error, omission, discrepancy, then within your agreed role, expertise, responsibilities, the engineer doesn't have to become an architect or vice versa. Within your own role, you've got to come up with some ideas of how we might get out of that without additional cost or time or compromising quality. Of course, it's the art of the possible, but it's bringing it to people's attention, getting it into the room, getting it into the core group to see whether there's a solution of the type that they came up with at Buick Court, and something that where we can see the reciprocal altruism is going to solve the problem for us. Okay, and that, I think, underpins this BIM clash detection very well. It motivates people to try a pragmatic solution. Give it a go. You're not going to get yourself into trouble. Okay, we're getting towards a close here. There's just a few more points I want to make on the BIM-enabled aspects of Cook and Wood, and then I will move to the getting the prisoners out, and then we will have a little glimpse into the future, and then I'll stop. Okay, IP. Remember, this is a contractual hub. We have something quite useful here, which is a set of mutual IP licenses. Everyone can see what intellectual property rights are owned by the entire team, or are ostensibly owned, and what licenses are being granted to enable the project to be built and ultimately maintained. I think that's helpful. There is also an exclusion of liability linked to the declared purposes. Now, I mention that because there's a thing out there called the CITV BIM Protocol, which was a sort of add-on to conventional contracts. It's there. It was an attempt to enable BIM under normal contracts, under two-party contracts, but it's become quite defensive because it worries about people, firstly, not being paid, and secondly, having their designs used for unauthorised purposes. So I think it's quite bold that the team on Cook and Wood have signed up to run the project through these mutual licenses without any of this nonsense, if you'll forgive me saying so, about if you don't pay me, I'll take my ball away. You know, I'll remove the IP license. Because if you think about it, that brings the entire integrated design process to a grinding halt. And also, interestingly, no exclusion of liability for the integrity of electronic data, which is code for the computer says no. We've got everybody has a computer that's gone wrong. Everybody has some software that hasn't done what it's supposed to do. Regrettably, BIM is not a single leap to freedom from the vagaries of IT. And yet, again, I'm sorry I'm having a go at this BIM protocol that you haven't seen and whose author isn't here tonight to defend it. Well, that's tough, they could have come. In there's a lot of disclaimers around exchange of digital information and saying, well, of course, if it doesn't actually work in the software, we're not responsible. Well, of course, that means the poor old client is. Someone who appoints a programmer, someone who acquires software, has got to have some measure of responsibility for that software measuring up. And again, on the MOJ approach, because they're a big client and there's a big national alliance and there's a lot of work at stake, there hasn't been any resistance to a forthright approach. Yep, we're going to have our input to the BIM model, and yet we're going to make sure that the IT providers do their bit as well. Okay, just looking to the next project, Terry Stocks, who's with us, who's head of the MOJ projects and programs, and also leading on level 2 BIM across government, was saying to David Caron before we started that the next one up is the biggest prison in Europe, and that's Wrexham, North Wales, £250 million, using exactly the same approach. What they've done on Cook and Wood has worked. They're going to do the same again on this great big prison. It's out to mini competition at the moment. But the one thing they're going to change is allowing a bit more time. The time during that first phase, the time for the enterprise planning, if you remember what I was talking about there, needs to be stretched if you're going to get the maximum out of it. So they're going to give it 6 months this time. Now, I've talked about, there, builders going into prison again, talked about builders going in. What about getting them out? What on earth do I mean by that? This is what I mean. There are some very interesting initiatives that, again, Ministry of Justice is deeply involved in to do with the wider social agenda in this country and to do with reducing the number of prisoners in the prisons. It's a virtuous circle here. CITV, Construction Industry Training Board, kicked this off by setting some very compelling targets for the appropriate number of apprenticeships, work placements, NVQs that should come out of any project type, of any project size, and there's 4 of those categories relate to justice. But loads to housing, infrastructure, schools, they've done a ton of work on it, and that means the industry subscribes to that, because the industry are the ones who pay the levy to CITV, so clients can ask for that, contractors will provide it, because it was their idea in the first place. But then you get these frontline parties. Construction, is there anybody from Construction Youth Trust here tonight? Hey, welcome. And this is interesting, because they add the spice to it. And you must speak to this lady afterwards, because you'll get much better stories from her than you will from me. But what they say in their toolkit for life, which is expressly related to resettlement of young offenders, of young ex-offenders, is employers should be required to offer a minimum of training, placements and apprenticeships, and to use a certain percentage of local labour. Now, we've got a legal problem here. As I say, you can set the targets, and those go through EU procurement, and those could be serviced by anybody in the EU. But as soon as you say local, we run up against EU procurement issues. We have probably the most eminent EU procurement QC with us tonight, Michael Boucher, who promised not to ask me any nasty questions on EU procurement. I'll hold him to that. But the way we do this is look at the local aspect after choosing the team as part of an improved value proposition. So when we're competing, when we're setting up the team, it's open to Europe. We can't localise it. Once we've got a team, if local subcontractors, local labour is better value, you're working with the team to do things that they agree to, which I hope Michael will agree to as well. Now, the interesting part of this, I suppose, is what actually happens on the front line. As I say, you're going to get some good stories from CYT. One of the statistics they give us is that 90% of those under 21 who come out of prison will reoffend. So that's not good, within 2 years. Of that, they say 97% would rather not. It's only 3% of them are career criminals. 97% of them really would rather not. And 68% say a job would actually help them not to reoffend. I think we could probably have worked that out for ourselves, but it's good to have the stats. And what the Construction Youth Trust have done is work very, very closely with prisoners directly to give them construction skills. I'm going to tell an outrageous story. Don't you let this get back to your patron. The patron of the CIT is the Duke of Gloucester, and I was with the director of CIT and she was doing a presentation to him saying that we're teaching prisoners construction skills, to which his response was, well, I hope they don't teach them tunnelling, which I think is a pretty good joke for a member of the royal family. Now, a more down-to-earth story is CIT worked with Enterprise, and a lady called Mary set up this scheme, Mary from Enterprise, with HMP Onley and HMP Sudbury. Well, they were a long way away. The building site was in Stafford, a long way away from the prison. She was a long way away. She drove up every day, collected the prisoners, took them to the building site, waited for a while. When they finished, took them back to prison and drove home. Now that's dedication. What I love is the next stage, where she then got them a car so they could drive themselves. And I just think that's great. You know, this is enabling people who are still in custody to come out, presumably at least temporarily, pick up their license and some insurance, go off to a building site and start acquiring the skills that will stop them reoffending. Okay, I'm now going to come to a close with one slide, and you're going to look at the pictorial slide, and anybody who's familiar with Oscar Wilde will, in the words of Lady Bratton, say a sandbag, and you'll wonder what on earth this is about. Okay, we've got a couple of quotes there. What partnering needed to succeed was BIM, and this risk-managing collaboration concept will probably return to favour in supply chain relationships. Well, clearly MOJ are the living proof of that. There's all sorts of things that can happen in the future to take contracts and contractual engagement and the way that people work as teams to another level. Because with level 3 BIM, they're now looking at the entire asset life, the entire asset performance. There's some fascinating stuff going on. My good friend Jason Russell at Surrey County Council described a sister contract for BBC 2000 as being like his iPhone. It's intuitive. He only said it once, and he said if he had 10 quid for every time I've used that quote, he'd be a wealthy man. But Andrew Vickray and I of Crowers wrote TBC 2005, and it is serving Surrey very well, and it is looking at whole life cost and whole life value. Whether it's intuitive is perhaps pushing it a little bit. But I suppose the sandbag thing, this was the flooding. Surrey and Keir were working very well together under their TPC. They'd achieved their savings, they'd achieved their apprenticeships, they'd achieved their increased sustainability through recycling, their extended warranty, and indeed, for those of you who could like to download another case study, you've got an exact breakdown of where the savings came from, including from a supplier, from a subcontractor, by agreement, not by coercion. So you have these processes I've described taken into a wide arena, if you like, in the entire management of Surrey's highways. But I think it's only fair to say that Keir and, of course, the Army didn't need a contract to turn out and fill 50,000 sandbags 24/7 to try to help the good burghers of Surrey who'd chosen to live by the riverside. They did it because, despite the prisoner's dilemma point, despite all the stuff around game theory, people do actually sometimes do the right thing instinctively. So we're not suggesting that contract forms govern every aspect of human behaviour, but they need to support the right behaviour. And I'm going to end with a wonderfully unfortunate conversation I had with Mark Bew, who hoped to be here tonight, and he's leading the entire government initiative on BIM. And he and I were talking on a conference call with some other people about how we would describe and take forward level 3 BIM, and they were using a lot of technical language. And at one point he said to me, David, I'm not sure whether you've got the picture yet. And I was on the conference call. I thought that's a bit rude. Bloody hell, I'm doing my best. He was actually trying to email me a diagram. I hope that I've given you a little bit of the picture. I'm certainly very proud and grateful to be at King's, where if there's any place that I'll get more of the picture, it's here. And thank you very much for listening to me.
So David has agreed to take some questions, and I'm going to let David moderate that himself. You can sit or speak.
I'll happily wander around unless it's intimidating. I'm very happy to take questions. Those of you who are students who've got exams coming up, this is not a revision session, that's next week. So don't be too harsh on me. But please, over to you. Questions or indeed comments? Go on, who's going to go first? Hey.
A general question, David. Was Heathrow Terminal 5 a serious setback for relational contracting, do you think?
Can you tell me what aspect you think it went awry?
I don't necessarily. I'm asking you whether you think...
I don't know enough about it. I don't think it was a setback. I think BAA would say they procured it on an entirely collaborative basis. They paid people very generously. I think that T5 is like a project that I worked on, which was the Eden project, with Derek Johnson, who's there somewhere, and like the Olympics, which I had nothing to do with, Some projects acquire cult status. They get that thing where people will go out of their way because they're associated with this project that everybody knows about when you're in the pub or when you go home in the evening. And if you can get cult project status, it's a huge help to collaborative working, and some of the science is perhaps less necessary. Not every project can get that. So I think T5 is a collaborative project, but probably with the benefit of quite a sort of boost from the way that it was built up.
Perhaps they used the wrong sort of contract.
Sorry?
Perhaps they used the wrong form of contract.
David, I have a question. In terms of causation, why now? You know, relational contracts, this PCP 2000, it seems to make such sense, right? And we want to think about where it's going. So what's driving it? Why does it start now? Is it that somehow commercial norms have broken down and you need to build the relationship by contract? Is it that technology makes it possible? Is it simply the scale of the projects that are requiring?
I think commercial norms have proven amazingly dysfunctional in construction. So I don't think anybody felt we had a good situation that has gone wrong. Yeah, never. I think we had a very difficult situation, which is why people so enjoy the master's course, because they learn about the science of those difficulties. Certainly one of the things I've learned with PPC 2000 is that people find it quite hard to digest a huge amount of change. There are many people here who've used it consistently and very successfully for 12 years. There are many people for whom it's so counterintuitive, it's not what they're taught. What I think is fascinating about this, so the drivers are oddly shortage of money, but as you rightly say, combined with technological advance. We've got a medium through BIM, and we've got a necessity through the recession. The recession hasn't gone away in terms of the public cutbacks, whatever the Chancellor says about growth. So the public sector has to save money, the public sector has a social responsibility, and the public sector has committed itself to technology. The way they've gone about this, and again, I don't sit here praising anybody for political reasons, is very impressive because they've tested these recommendations through their own trial projects with input from people like ourselves, and they're now committed to training and supporting those who want to roll them out. And I think it's the training. I think that people need a particular type of training to move them away from a fixed paradigm, and there's certainly a fixed paradigm in construction procurement. Partly legal training, partly behavioural, partly project management. And if there is a public sector commitment to that, I think our public sector is in the right place to bring it about. But this is the beginning of what looks like a committed journey. What one hopes they'll carry on.
I have another one. Oh, go ahead.
You've linked it quite closely, partnering quite closely with BIM. Would it be possible to run it successfully on projects without BIM? And also, you've quoted that figure of 20% savings. What proportion of that is from BIM and what proportion from the partnering approach?
If Mark Bew was here tonight, he'd say it's all BIM. And since Kings have investigated it as partnering, we'd say it's all partnering, but it's actually a combination of the two. No, it is very possible to implement two-stage open book and partnering without BIM. And the other two published trial projects we have already, one of them is Hackney Homes, SCMG, and there are a number of people here from there tonight, Jonathan Oxlade in particular, who could talk to you later, and the other is Surrey. Neither of them have used BIM. BIM is an enabler, a catalyst for these approaches, but it's not a precondition. The savings, I think, I'm going to talk about the Surrey savings. I was going to put up a slide, and I thought, no, it's becoming too detailed. What's fascinating about the Surrey savings is with Kier, with Aggregate Industries, who are a rough, tough old supplier of aggregate, and with Marshall Surfacing, who are a local surfacing contractor in Surrey, they sat down after a tier 2 competition and said, look, we've got £100 million worth of work that all of you could win, but we need to do £115 million worth for our 100 million, if you see what I mean. We need 15% savings. Well, They came up with this: 1% the subcontractors would take off if they were paid on time, because they still weren't. If anyone's from Kier, sorry that they weren't. 1%, 2% if we could have a local depot. Surrey had a local depot. Another 2% if we could be involved in the diversions and the access, so that we can deal with residents in an intelligent way and we're not always being obstructed. Another 2% if we can plan the work so it flows through the year. And everybody, particularly in London, will know how much by way of roadworks is done in February and March, just at the end of the local government financial year, to get the spend through. Everybody would prefer it to be evened out, subcontractors included. And it is, in that case study, a fascinating breakdown of where the savings come from. And they don't come from the blanket adoption of an approach, whether it's two-stage open book or BIM. They come from the opportunities for people to talk to each other and work things out. I find that very compelling. And in terms of, David's question of why now, will it fly this time, because people have clearly been striving for improvement for a long time. I think that sort of breakdown, that undeniable evidence, starts to make a very strong case.
Anna, in the back.
Hi, David. That was fascinating, especially for someone who, for those of you who don't know me, I'm one of David's colleagues in the law school, and I am a bimbo when it comes to construction law. So I've learned quite a lot tonight. So my question comes then more as someone who is a colleague in the law school than as someone who's in the construction law sector. It seems to me that what your inaugural lecture has demonstrated to us is that lawyers need not just to be dispute solvers for their clients. They also need to be able to, if you like, avoid disputes through careful construction of legal relations, so that essentially the dispute never arises. Because once that happens, to a certain extent, everyone except the lawyers lose. So I'm thinking from the point of view of you and I and other colleagues educating students, what are the skills we need to foster so that they can go out into the world and do this kind of work, which is so very different from the kind of classic orator before a courtroom.
Well, Kian, thanks very much for that question. If we look at the Centre of Construction Law for a moment, and this is not of my making, this is John Uff and Philip Capper who put this together, they've created a multidisciplinary MSc in construction law, because I think the key is the connection between lawyers and other professions. And I think when lawyers are talking to lawyers, it's very difficult to get that enabling mentality, that crossover. If you're dealing with architects and engineers and surveyors, and indeed if they're acquiring legal skills, the translation becomes that much more easy. We've got students on the course, some of whom are here tonight, whose greatest ambition is to be an arbitrator or adjudicator and to sit in, in considering the complexities of a dispute. I hope, as you've suggested, that some of our students will see the potential to do something quite different. We've looked at EU procurement, not from an overly analytical point of view, but from a procedural point of view, as a way for lawyers to influence the way that teams are set up. So in the public sector, clearly you can take a particular legal skill, swim upstream with it, and then try and get to know the clients. But the way that lawyers get involved and the way they want to be involved, I think you've put your finger on it, is a very challenging issue. Giving them related skills, whether it's facilitative or training, or a different type of negotiation, or indeed a type of alternative dispute resolution, and Renato Nazzini and I have discussed this, is a part of it. But certainly I agree with you. I think if we're going to enable lawyers to have the influence that I'd like to think they can have, we need to help them along the way.
Can I just contrast that, or follow on that question? So on the one hand, you said the long-term relationship works because it becomes the law of business. It's in each other's self-interest. But then the example you gave was a dispute, a budding dispute, in which you put designated people in a room. Mm-hmm. I assume the designated people in the room were not the lawyers, number one. Number two, if it worked with someone who was not a lawyer, is it because, in fact, there is some commercial good faith practice or uncomfortability in the room with the whole
it's not that they really are thinking out perfectly their self-interest of being obstinate.
Right. The Buick Court example, I was something called the partnering advisor on that project, which is a little bit of luggage that comes with, optional luggage, comes with PPC 2000, and it is the lawyer doing the things that Kian suggested. It is the lawyer bridging the interests of the parties and looking at them collectively and seeing whether they can facilitate the progress of the relationships through the project. And the role of the partnering advisor is something that I still fulfill on a number of projects, and that others do as well. There's an association of partnering advisors. Not all lawyers, certainly not all lawyers from my old firm Trowers, all sorts of people, but it's individuals rather than firms. And I think that's an interesting point in itself, because the meeting of individuals can only be facilitated by an individual. So the facilitative role of lawyers, and I should have mentioned that earlier, is something that came to life about the same time as PPC 2000, and has been actually the most difficult thing to embed. There are about 60 of these individuals. They do fulfill that role, but I have to say that an awful lot of clients, 90% at least, see their lawyers as their mouthpiece when things get tricky. They do not see their lawyers as their facilitators. That's why it's such a good point. On that one, the key that unlocked it was a surveyor in the small firm of QSs in Newcastle. Just to add a little bit of colour to that story, Kendall Cross came along and said, look, our cladding subcontractor's gone bust. You remember them, we jointly selected them. There isn't another cladding subcontractor within reach. It's going to cost a fortune for us to substitute them, but they're our responsibility. And the surveyor with this very small firm said, we need to have one of these core group meetings. This is an early warning. The client, it was a great big housing association, said, I've got no time for that. It's the contractor's responsibility. Let's see them get out of that without moving. And this QS badgered away. And he had that quasi-legal knowledge that many surveyors do, and he also had a hotline to me, and we got them into the room, rather against their will. Once they were in the room, these more, this reciprocal altruism, this common sense, in other terms, came to life. Once they're in the room, they didn't need to be shepherded, but getting them to obey the rules of engagement, to come to the room and listen to each other, was a bit of a struggle. So I think that the way that people behave when they're sitting in their office with their advisor or their colleagues and telling themselves they're 100% in the right and everybody else has let them down, is a fascinating contrast to the way they behave when they're sitting across the table from someone they're really quite annoyed with, but have to have an exchange. And that's the key.
David, I wonder if you see any opportunities outside UK waters for PPC 2000, and what stimulated the question was some of the preface you put at the beginning of your lecture around the burning platform the construction industry had, slightly dysfunctional, and also a recession. So as a practitioner working in other jurisdictions, I can see some parallels here, perhaps as Australia cycles through a different economic cycle, as America even is faced with a huge fiscal cliff. So I wondered if you had a view on how it might be applied further outside this jurisdiction.
Thank you, John. I have to sort of slightly distance myself from PPC 2000 because I've got no rights in it or wish to promote it other than a sentimental one, but the model, shall we say, whether it's through that contract or through another one. Two things. One, we've given it a spin in the Middle East twice. The British Embassy in Doha was built by a commissioner built by the FCO under that form of contract. And Derek Johnson and I worked very, very hard on a university hospital in Dubai under that form of contract, as you know, all bells and whistles until the recession came to Dubai as well. And what was a beautiful university hospital became a significant 4-storey underground car park. So it can be done. The exportability of this, I think, is linked to the exportability of BIM. I think BIM is being looked at very closely all around the world, and enablers of BIM are the key. I was sitting with Mark Bewan with Terry earlier today, and Mark, who thought he was going to be looking at the technical issues around BIM, said 80% of his time is spent talking about procuring the data. And procurement, in the sense that we would know, putting a team together in a way that it opens up that data and shares that data is a challenge. So I think that it will be proven very quickly, I think, that traditional single-stage models don't enable what you get out of BIM, and something that looks a bit like PPC 2000 and may even sound like it would be very exportable if it helps to overcome that.
Well, thank you very much, David. Please join me in thanking our speaker.